In this recording, we're going to be looking at property. Now, property is a very large area of law in the broader sense. And so for this recording specifically, we're going to be looking at physical property, things that are actually tangible in nature. In subsequent recordings, we're going to be looking at securities and rights to do with debt obligations. And in another recording, we'll look at intellectual property. For now, though, the areas that we want to look at are real property, which is land and buildings, and personal property, physical objects that are capable of possession. We'll also talk briefly about this area of law known as bailment. It's a separate and distinct area of law involving the passage of party in terms of possession from one person to another. And finally, we're going to look at a very specific type of security where one party holds what they call a lien across a specific piece of tangible property. So starting with a definition of what property is. Now this is actually quite difficult. We find in our day-to-day lives that we have essentially an ordinary or a lay definition of what property actually is. And by and large, this aligns with the legal definition of property. When we're thinking about the law in relation to property, the way that this has been expressed both by philosophers and by jurists is that it's really about rights. It's about the relationship between people and the duties and obligations that they have between each other. And the High Court in Yana and Eden referred to this as a packet or a bundle of rights. But to many of us, that's kind of unsatisfactory. And so I'm going to go through in this recording and really try to map out and express and explain these rights in a little bit more detail. Just want to start with a few definitions. Now, there are some additional terms that we'll come to throughout the recording, but these four from the start, I just want to explain. The concept or term real property refers to land, and real property is different and distinct from personal property. Now, personal property includes everything which is capable of being owned, both tangible and intangible things. And again, I'll explain these both later in this recording and in subsequent ones, that certain things are capable of being owned, but they have no physical existence. When we are thinking of physical objects, one of the legal words that we use to describe that is chattels. Now, in the context of fixtures and chattels, we use this term chattel specifically to describe objects that are not attached to land. And so when we use this term, it's an old French word, it specifically means items of physical property that are not annexed or not attached to land. Finally, there's a few technical legal terms that differentiate things that can be physically owned and things that are intangible in nature. And for these intangibles, we use this term choses in action. That's the plural, singular just being a chosen action. This is, a legal right that a person has to bring about a certain result. Now, this can be in the form of some form of intellectual property, or it could be something like a bare right to sue. And I'll go through these in a bit more depth later in the recording. One of the reasons that land law is a difficult area to explain and why it's not particularly intuitive is that to get a really good understanding, you have to look at both the history of the law as well as the underlying political dimensions, particularly in terms of this idea of nations conquering or taking or trading away land. Now, you may recall from an earlier lecture, we talked about the old model of Westphalian sovereignty. And that's that idea that before the Second World War, the nation state was essentially the highest power that could exist. And nation states, even though they didn't necessarily like each other, they at least recognized each other's existence. And part of this recognition and this understanding is this idea that land could only really be acquired in quite particular ways. And the first, most direct way, of course, being conquest, when one nation goes to another and just takes it over through an invasion. The second mechanism for taking land was through treaty or through some form of succession, where a nation either voluntarily or involuntarily comes to some arrangement for the transfer of or swapping of land. And finally, the doctrine of terra nullius. This is the idea that when representatives of the nation states come to land with no people on it, that they can take it or claim it by physically demonstrating that they have done so. And so when looking at these doctrines and thinking about this, the idea of might is right and the ability for people with large armies to take things, again, under this old model, was exemplified really in 1066 when William the Conqueror came across from Normandy in France and took over England. And with his army, he proclaimed himself the king across the entire area. That was how he gained sovereignty over all of the land. Now, in 1770, when James Cook was sailing around the South Pacific, he came to the then supposedly unoccupied land of Australia and claimed it, at least the eastern part of it, on behalf of the British Crown. And this doctrine, which remained really a core theme of the Australian sovereignty story up until 1992, is this idea of terra nullius. The land had no civilized occupants, therefore the British felt that they could claim it and declare that the Crown now essentially has possession over the entire continent. Now, we use this term Crown land still today to describe this idea of the original grant flowing from this original acquisition or assertion of sovereignty. So the starting point is, at the very, very baseline, every point or part or package of land in a country belongs to the sovereign. And it's only through the sovereign choosing to give components of that away that individuals and people can actually own or privately hold property. But there are still areas reserved and held and owned by the Crown. Now, in Queensland, for example, this really refers to the state of Queensland, or formerly the colony of Queensland, which was formerly the colony of New South Wales. That was how land was originally held, and there are packets of land still held that way. So if we think about this, national parks, for example, areas of land that never actually were privately held. They've been owned by the state from the point of the original acquisition or assertion of sovereignty. Now, again with a bit of history, if we think back to medieval times, so after William the Conqueror took possession of England, he clearly couldn't run all of the land himself directly. His army couldn't be in all places at all times. And so, following the systems that existed in Europe at the time, William would essentially outsource. He would get usually one of his friends or a local noble family and say, okay, this big tract of land, all of Cumbria or all of Southampton or all of Yorkshire, is now going to be run by you. It's not to say that the king is losing authority of that. All he's doing is essentially deputizing. And so these people who is essentially just one level below the king owe him homage. And part of this homage is to provide a combination of food and military service or religious services back to the king when he demanded it, or as most commonly was the case as time went by, money. Now, this process of creating deputies across areas was actually repeated to essentially form a pyramid. So that the people that William originally granted land to, they also couldn't really actively control all of the large tracts of land that they had, so they outsourced. So they, what we call sub-infeudinated, so that the you had people who had large areas of land who owed homage to the king, and then there were slightly smaller areas. And those people in those smaller areas owed homage to the person just above them on the pyramid. They didn't pay the king directly. They paid their lord, and their lord would then pay the king. And this process of sub-indentation could actually occur across multiple levels. It could be up to a half dozen levels. One of the difficulties of this, of course, is that people at the ground level, commoners, did not own the land. They had no means of acquiring the land. They worked on it, and they owed homage to their own lord, but they were essentially slaves. And in fact, the word that we use is the Latin word serf, which refers to service, which really means slave. This process or system was known as the feudal system, and it's a characteristic of medieval Europe. Now, the feudal system was slowly dismantled over a long period of time, but it's important to note that some components of this, and in particular, the idea that the crown still has absolute power to grant land to people, is something that still remains in some guise inside our legal system today. Now, as the feudal system was slowly dismantled, and this idea of paying homage to the next person above you was started to be removed, the courts of common law had to create a new series and system of rules in order to govern this, because there were still many situations where families could hold land and didn't necessarily owe homage to their lords or had to pay some form of rental tax. But it was important to have systems in place so that the families could pass the land on to future generations. This became an important aspect and an important theme. Now, this idea of being able to have these grants of lands and to create what we call estates is really tied into this idea that you can create a grant in land that is lesser than the one you currently have. What does that mean? It means, for example, if you own land completely outright, free of any form of encumbrances, let's just say there's no mortgages and you have no other party that you owe things with in regards to land, you can actually choose to create a lesser grant across the land. For example, we use the term lease to describe a lesser grant for a fixed period of time. Now, as well as being able to do these things in terms of short-term leases, you could also have particular grants that could only be passed across generations in certain ways or mechanisms. Now, a good example of this comes from the works of Jane Austen. Now, for those who may or may not be familiar with Pride and Prejudice, and that story is set around the early 1800s, late 1700s. The land was owned or granted with what's called fee tail. So what that meant was that it could only pass to a male heir. And so the father of the family that owned this particular piece of land had 5 daughters, and so the plot of that story was the quest that he had to try and find good suitors for his daughters in order for that land to be appropriately passed and maintained and kept through the family. Now, this idea of fee tail doesn't exist anymore in Australia. It's been formally abolished in all jurisdictions. But one type of grant that does still remain is the idea of a life estate. And essentially, that is where title or ownership to land is passed to a person, but it only lasts for the life of a particular person. And so a classic example might be a wife, for example, owns a plot of land or a house, and in her will, for example, may grant a life estate to that to her surviving husband. So even though that they didn't jointly own the property, she owned the property outright and would create this grant that would last for as long as the husband is alive. And then as part of this grant, it would stipulate what would happen after the husband died. So for example, maybe to pass on to children or plus to other family members. Now, the key thing to note here is that life tenancy can actually be transferred. So the husband could, for example, on-sell that grant to someone else, but the length of that life estate is still keyed to the husband's life. So that I guess the lesson from this is that if you are to purchase an estate where there's been a grant via a life estate, just be very, very mindful that the life of the person that it was granted to is the length of that particular estate. Now, the most common grant of land that we have in Queensland is what we call fee simple. That is the idea of a grant of land that's been made with none of these sorts of restrictions to it. This was a relatively late comer in the British land law system, but these days it is the dominant mechanism in which land is held. Now, I mentioned earlier that a person who has a great or a higher level type of estate can grant lesser estates to other persons, and a very common way of doing this is via a lease. And a lease is a right to have what we call exclusive possession of land for a certain period of time, and this can either be a fixed term or it can be what we call a periodic term. So this, for example, is most commonly done with residential tenancies, or it can be unspecified terms, what we call a tenancy at will, and that's where a person keeps paying periodically until either party decides to end it. Now, leases used to be governed quite heavily by the common law, but in more recent times, the last 50 years or so, have really Parliament's really sort of intervened, particularly in situations where there's a great deal of power imbalance between the two parties. And again, the classic example there is residential tenancy, where often the landlords are in positions of power in terms of negotiating terms and conditions, and tenants have relatively less power. And so as a result, the residential tenancy legislation carefully maps out the obligations of both tenant and landlord, and provides mechanisms in terms of the entering into and the ending of residential tenancies. Similarly, in recent times, this idea of the Retail Shops Act. Again, there's this recognition that in large shopping centres, that the Stockland and the big owners of property have a lot of bargaining power in terms of how they negotiate with contracts with individual smaller retailers. And again, Parliament has intervened to create a series of statutory mechanisms really to regulate and in many ways to try and offset that inherent power imbalance between the parties. A couple of other things about leases. First of all, leases can be registered or unregistered. Leases beyond 3 years must be registered in Queensland, and leases are often governed by the internal mechanisms of contract law. Again, particularly between commercial players. We've talked about this relationship of bargaining powers and putting specific terms into the contract, and generally that is left up to the parties to do. So outside of these certain circumstances, say retail shops and residential tenancies, the common law rules of contract will very much apply. Now, the next important aspect of property that I just want to talk about briefly is this idea of co-ownership. Now, the examples I'm going to be using here are co-ownership of land, which is I guess the most common reason why these things end up being disputed in the court system. But also note that all of the rules of co-ownership will actually apply to personal property as well. Now, fundamentally, there are two basic ways in which property can be held at common law. And this is the idea of, or the concept of, tenancy in common, which is where the parties have a clearly mapped out share in the particular property. So say, for example, you and your sibling might own a house and you might just have 50% each, or it might be 75-25, or it might be 99 and 1%. Either way, you are both deemed to be co-owners at law, regardless of what that percentage is, which is an important thing to note starting with. Now, the key thing about tenancy in common is that those shares can be bought and sold. And so that the person with 99 could on-sell that to another party, or the person with 1% could on-sell that, or they could sell it together to the same person, and in which situation that joint ownership will dissipate at common law anyway. Now, tenancy in common is the most straightforward, and it's also the most mainstream or commonplace mechanism for jointly holding land. There is another form of co-ownership known as joint tenancy, though, and this was historically the most popular one, and that is the idea that two or more people own the land at the same time. They don't have a particular share, but they do have what they call the right of survivorship. What that means is that when one of the co-tenants or one of the joint tenants dies, the others just carry on being co-owners of the property. And if there are only two co-owners and one of them passes away, then the other person owns the thing outright. Now, as you could imagine, there are some pretty straightforward complications that can arise from that. For example, the courts have noted for a long time, particularly in their jurisdiction of equity, that this can actually lead to some pretty unfair results. If, for example, four people own a particular property and they all have, for example, 2 children each, what that means, if the property is held jointly, is that the last one alive, it's really the last man standing, gets all of the benefit of that property. And so in that situation, only the children of the surviving co-owner would inherit that particular property. And this can be really problematic, and that's why equity always prefers things to be tenancy in common and ideally shared equally as well. Another complication that can arise is if co-owners die at the same time. Again, just imagine you've got 4 co-owners and they have a car crash. And this was always problematic when you're trying to work out, well, if they all died at the exact same time, who is going to inherit the property? And again, equity would intervene by trying to resolve this and make things equal. But strictly speaking, at common law, there are a strict series of rules that the courts would go through to determine who was deemed to actually have died first. And again, it can create some pretty unjust situations, as you can imagine. Now, key aspect of this co-ownership, regardless of whether it's joint or tenancy in common ownership, is that co-owners both have rights to occupy and use the land. And if one co-owner somehow limits that or prevents the other person from taking possession of the land or from using it, then they can be sued under this doctrine known as ouster. This is where a co-owner who's been excluded from the land can sue the other owner or owners for what we call mesne profits or occupation rent. In other words, what would have been earned, or in lieu of what would have been earned, for example, if the house wasn't actually rented out, what a reasonable amount for what it could have been rented out for. And it's important to note here that co-ownership, particularly in situations where you have owners that don't really get along, the courts for a long time have said, look, this really isn't a very suitable arrangement, because not only are you not entitled to exclude other co-owners from the property, you also can't make them contribute towards the property either. You can't force the other co-owners to pay rates or maintenance or do upkeep. Again, these things can be calculated for if the land is actually rented out or is somehow used or utilized. And you can calculate that in terms of some form of offset, but you can't by right go to the courts and make someone, for example, pay the rates or their share of the rates on a house. So it's important to note that these mechanisms of co-ownership in common law also do apply for leases. And for some of you may or may not be familiar with residential tenancy leases, in situations where you have multiple people on a lease, and essentially you end up being co-owners in that situation. Again, with residential tenancies and retail shop arrangements, these things are governed by statute, but fundamentally the common rules do sit there, and they do say that by default you really have a hard time trying to force other co-owners to do things, unfortunately. Okay, now an important thing to note about owning land, for those that are fortunate enough to own land, unfortunately, you may or may not know that you do not own any gold or silver that you find underneath your land. This is an old common law rule that has been around for a very, very long time. The Crown always has title over all of the they're called the royal metals under your land, being gold and silver. Now, in Australia, there are also various statutes that go towards regulating how things work in terms of other precious things that may be under your land. Petroleum being one, but also uranium. It's actually quite an interesting area of law because for a long time, both the courts and the parliaments of the states and territories were very much of this idea that the state governments own all of the resources under the land. And unfortunately, the High Court, at least in Obiter, has sort of cast a little bit of doubt on that, particularly in relation to uranium. Things that really only happened or became valuable after Federation, so from the 20th century onwards. Now, another key thing to note is that when you have AIM, not only do you not own the things underneath it, you actually don't own, and you can't sue in terms of interference with, things that happen a long way up and a long way down. Now, there used to be an old Latin maxim that says that a person owns all of the land to the heavens above and the center of the earth. But in more practical, reasonable terms, the owner of a land can really only own, and again, can only sue for trespass, to what they can actually reasonably control. Now, in Bernstein and Skyviews, Skyviews was a company with a business model where they would fly planes over large stately homes of rural England and take photographs, and then take those photographs and try to sell them to the owners of those homes. And Lord Bernstein tried to sue them and say, hey, you are actually trespassing upon our land when you're flying over, to seek some form of remedy. And the court disagreed. They actually found on behalf of Skyviews and said, look, you are not actually making good use of the land above, and that Latin maxim really doesn't apply in that situation. Similarly, Bocado and Star Energy was to do with oil rights underneath a packet of land. And in that situation, the court said, look, we do fundamentally agree with you in that, in the argument that, well, if the oil company can get underneath our land, then we could have been able to get under our land. So that's, strictly speaking, going to be a trespass. And the court said, well, we do fundamentally agree with you, but they actually only awarded a token amount in that case. I think £1,000. It's a British case. So at first instance, they had won a large sum of money, $600,000 or £700,000, and that was reduced because the Court of Appeal said that, look, this is really just a technical trespass. It's really just a nominal amount that you're entitled to. You were never going to drill for oil yourself. And so as a result, and again, it was a 3-2 majority, so it could have gone either way. But the key thing to note there is that it's all about whether you could have reasonably used the land or not. And there they said, well, you could theoretically have used it, but in practical terms, you probably wouldn't have. And so we're not going to give you 10% of the amount of oil that was there, for example. We're going to turn our attention now to the attachment of things to land. This is an interesting area of law, although largely relegated by contract, particularly standard form contracts for the sale of land. But it goes like this. If an object is attached to land, so much so that it forms a part of the land, then it's deemed to be part of the land itself at law. And so basically what that means is that if you were to attach an object, say for an example, a spa pool, if that was to be affixed and attached to the land, it becomes a permanent improvement to the land itself, rather than being something that you pick up and take away. And this is important when land is bought and sold. It's also important in terms of tenants, in terms of tenants coming and putting things onto the land. Now, there's 3 tests that the courts use for determining whether or not a particular object or item is attached to the land, which we call a fixture, or an item of personal property that can be picked up and removed. We use the word chattel to refer to objects in that way. Now, these 3 tests are the objective intention test, which is really to look at what was in the mind of the parties when the object was affixed, the purpose of the particular object and the action of annexation itself, and the degree, to the extent that the object is attached. And we'll go through each of these in more depth right now. Now, the first of these 3 tests, this objective intention, operates by looking at what a reasonable person would think when looking at that particular object and when it's getting affixed to the land. Would a reasonable person normally consider that particular object to form part of the land itself, or would a reasonable person think that the owners of that particular item would pick it up and remove it when they came to leave? This is from the case of APA and Coronio. The facts of Coronio's case were there was a purchase of a movie theatre, and the incoming buyer of the theatre went to court to argue that the projector, the switchboard, and the chairs were all fixtures because, to be honest, unfortunately, it wasn't mentioned in the contract. Now, with a lot of these sorts of rules, it's important to note that while, we can look to the contract to see maybe what a reasonable person might think in terms of whether things are fixed in chattels, but more importantly, if the things are carefully mapped out in a contract for sale anyway, that is going to trump each of these 3 tests. So it's an important thing to note. This is an area of law that can be changed or modified through private agreements. And again, really that's the golden rule here, that if you were to purchase property, make sure that you've carefully mapped out what things are going to be fixtures and going to come to you as the purchaser, and what are going to be chattels and will be removed by the seller. And so in Coronio's case, they said that the projector and the switchboard, using these other 2 tests actually, the test of annexation, purpose of annexation and the degree, and they looked at that, thought, well, a reasonable person would think that because the projector and the switchboard were so firmly attached, they really form part of the land, but the seats could just be picked up and moved out and relocated. And so therefore, seats are going to be chattels, the fixtures and the switchboard are going to be fixtures in that case. which is capable of physically being taken, held, and possessed. So I've got some examples here of choses in possession. The first one is goods. We've already talked about sale of goods when we're looking at contract law. Other thing to note here is that physical money, so actual banknotes that we have, is deemed to be a chosen possession. That is something where you can physically go and take possession of it. But this is different and distinct from bank accounts. Bank accounts are rights that are to money which is held with a financial institution. Other things that you can actively possess is capital equipment, even if you can't physically pick the things up. Assuming that they're not attached to land, they're going to be chosen in possession. Ships, so boats, no matter the size, are considered to be chosen possession. And similarly, pets, animals are not sui juris. In other words, they can't sue or be sued. They are items of personal property that you follow. Again, there's certainly sentimental property. There are some special rules associated with those things. But essentially, the rules of personal property apply in terms of the buying and selling and transferring and assigning of such things. And similarly, emblements, where a person gets a right after harvesting, after sowing crops, there's right to come back and get the crops and take them away. Now, there are, however, tangible things that aren't chosen in possession. So physical things that exist in the world that are not items of personal property, either because mechanically they can't be possessed or the law refuses to acknowledge them as things to be possessed. And so we use lands and buildings as the classic example here. We just define land and buildings to be real property. They aren't items that you can physically pick up and move around. Similarly, human beings are not capable of being owned, and human tissue and fluids, the courts of common law have for a long time said, are also not capable of being owned as well. They are not property within the eyes of the law. And again, there are other rules, and certainly these days statutory rules that govern how that form of property is to be used. Similarly, airspace in itself, and again, this comes up, airspace and waterways, when we're thinking almost of more abstract concepts, then it's not something that you can physically pick up and own. They're not chosen in possession. Checks, even though a physical check exists in the world, we can actually have a little piece of paper. Fundamentally, a check is only a right to do something. So even though there is a physical piece of paper, and there are certain rules that govern the mechanics of using that physical piece of paper, at law it is not deemed to be a chosen possession. And in fact, you may recall from the contract law recordings, a check that has no money in it, so in other words, a check that's going to bounce, is actually invalid as consideration. You can't offer that as consideration in contract law. It means that the contract won't actually be formed with such a check. And finally, the High Court said that wild animals, so things that are actually out in the wild and haven't actually been caught and possessed by people, are also not chosen in possession either. Now, the flip side, other items of property that are capable of being owned but not capable of actually physically being possessed. Now, the law in the 21st century acknowledges a wide variety of these, and certainly there's a list of 20 on the slide here. So things like debts, actually having a debt to somebody is not something you can physically grab and pick up and possess. Similarly, a lot of intellectual property. I'd mentioned bank accounts and checks as things that are rights to something but don't actually exist in terms of being possessed. Also, your reputation and goodwill, your business reputation, counts for something. That there is an intangible association with that, and these things that can be bought and sold and traded and acknowledged in the eyes of the law. Similarly, you get the bare rights to sue. Rights to sue that can be assigned are deemed to be this chosen action. They're something that you can, the law will associate as them having some form of value, and in some circumstances they can be assigned. Now, there's a distinction here, though, between what we call legal choses in action and equitable ones. Now, and the key distinction is that equitable choses in action can only be assigned through certain statutory mechanisms. I mentioned earlier that property is a little difficult to define, and this idea of ownership of property, giving the owner some sort of rights, is a helpful place to start. And if we think about this from our experience, when we own things, we get certain sort of straightforward rights. This right to have it. We also get the right to give the thing away, either permanently or to give it to another for a certain length of time. We also have the right to charge others to borrow the thing for a length of time. And we know that these things are protected by the law. We can also, if we own either real or personal property, or even certain types of choses in action, we can have those and get third parties to come along and give us money to place a charge upon those. So a mortgage being a classic example with land. Most residential property has money owing on it to one or more financial institutions. Another thing to note about owning things and items of personal property anyway is that you get the right to destroy it. It's your thing. You can do what you like with it. And if others try to interfere with that right, then you get a right to sue them, either in tort or nuisance or some other area of law, in order to really demonstrate that your rights have been infringed, or to seek some form of compensation. It's important to note, though, that in many cases we don't have absolute power to do all of these things for all of our items of personal or real property. So we can think of some straightforward examples here being environmental protection regimes. A farmer can't simply clear a bunch of native forests without seeking the appropriate permits from the environmental authorities. Similarly, heritage-listed buildings can't simply be destroyed without the owner of the land obtaining some form of permit to do so. Land can't be conveyed, residential property can't be conveyed from one party to another without the rates being up to date. Similarly, cars can't be sold without it having a current system of registration and a certificate of fitness. An important one, though, here is to do with life tenants. There is actually a legal doctrine called the Doctrine of Waste that says a life tenant, a person with a life estate, can't choose to destroy the property or damage it or leave it in disrepair so that the person coming after them, what we call the remaindermen, have a diminished or destroyed estate. And there is actually a doctrine which enforces this and basically makes a party maintain their property to a certain standard. And so all of these things are restrictions, either statutory or common law rules, that really interfere with or diminish this absolute packet of rights that ownership would normally give a person. And another thing to note is to do with dispossession or alienation, in that the ability to assign property from one person to another, from me to dispose it or get rid of it, usually in terms of ownership of legal property, you can do as of right, again, subject to some form of common law or statutory restrictions on the particular type of property. Equitable property, though, these equitable chosen actions, you can only do this thanks to a statutory regime in sections 199 and 200 of the Property Law Act that says, look, you've really got to put this in writing, got to make it very, very clear what you're doing, and give notice to all parties affected by this transfer. Now, a phrase you might have heard throughout your lives is this idea that possession is 9/10 of the law. And while it's a little tongue-in-cheek, there is actually a little bit of legal rules and principles that really back this up to some extent. And it goes like this. Look, the possessor of an item of personal property does actually have greater rights than a non-possessor to all the rest of the world other than the actual true owner of that particular object, or those that the true owner has passed through some other mechanism, contract or bailment, that somehow passes on a greater right than what the possessor of the object currently has. And the case here is Amory and Delamere, and that involved a chimney sweep who found a ring. He took the ring to a local jeweler, and to see whether it was worth anything, the jeweler gave it to his apprentice. The apprentice ripped out all of the stones off it, and then when the chimney sweep came back, they handed back the ring, and he said, well, what about the stones? And they said, or tried to argue, that, look, this isn't your ring. We have just as much right to it as you do, and so we're keeping them. And so it went to court, and the chimney sweep won. And there the court said that, look, yeah, strictly speaking, you're right. If the true owner came along, then the true owner would take both the stones and the ring back and be able to sue for that. However, the finder does have some form of right. The finder of an item has a better right than others. In other words, other than the true owner. And in that situation, the chimney sweep actually did win. And so this concept of finder's rights does actually have a place in our law. It's important to note, though, that for most of us in the scope of our employment, if we find something, then we must account that back to our employer as part of our fiduciary duties. However, if it's not within the scope of your employment, then you don't. And also appreciate that for most of us, the scope of our employment is very rarely the finding of goods. In fact, it's only a narrow subset of professions where this would be the case. And so this Byrne and Hoare case of 1965, it's a Queensland case. In Mount Isa, a police officer, there was a request by a movie theatre owner, a drive-in theatre, could the police please come and attend? And so they had a police officer who was walking around and just making sure that the youths weren't being destructive of the theatre operator's property. And he found a valuable object in the process of doing that. And there the court said that, look, if this was a police officer just walking the beat, walking down a street on his regular duties as a police officer, then that probably would be within the scope of his employment. Hey, I found something. It's got to go back to the Queensland Police and back to the state of Queensland. Here, though, that wasn't the scope of that particular role that he was there for. And so there they said that, no, in this situation, it is not going to be within the scope of his normal employment, and he will have better title to it than his employer in that situation. Now, it's also important to note that if you find something on someone else's land, if it is a common area, in other words, an area that the owner of land is not actively asserting control over, then you will have finder's rights. You will have the better title to it than the owner. And Parker and British Airways bought that was a guy using the executive lounge for British Airways, and he found a gold bracelet in the executive lounge, handed it in, and they said, okay, we'll try and find the owner. Came back a few months later, said, oh, where's the gold bracelet? And they said, oh, a policy says we're going to keep it. And so they trotted away to court, and he won. And they said, look, if this was in a controlled area, for example, if you'd found it in the British Airways staff room, where there was a lot of staff in and around, then it would belong to British Airways if they're actively asserting control over that area. But in this situation, it's a common area, and they're not. And so that's a key part in terms of finding things, that active control across the area. It's also to note that when you find something, you get finder's rights if it is on the land. You won't normally get it if it is attached to the land. And so these examples here of Ewells and Briggs gas, there it was an ancient prehistoric boat was found, and it required excavation in order to get the thing out. And there the court said that no, in this situation, that is going to belong to the landowner. It is affixed to the land. And similarly with South Staffordshire Water and Charman, on the bottom of a swimming pool, certain gold objects are rings that were attached to it, but they had actually become attached to the base of the pool itself. In that situation, they are affixed to the land, and the landowner has better title than the finder. Next area we're going to look at is bailment. Now, bailment is an interesting area of law. It is actually a very, very old area of law. It actually predates both contract and tort. It flows from the Roman law, which itself flowed from earlier civilizations, and it really is to do with the rules governing personal property, where it is possession is given to another person in terms of what they can and can't do with it. Bailment's a pretty straightforward set of principles, at least for us in the 21st century. It basically goes like this: if you take possession of the goods of another, then you have certain duties to take due care of those goods. It's an objective test to take care of them, to retain possession of them if they're given to you to hold for a certain length of time, to not do things that you're told not to do with them, that's unauthorized use, and to give them back when you're asked to. Now, bailment is a separate and distinct area of law, and a person can sue or be sued in an action on bailment, and often it runs alongside actions in tort and actions in contract in particular. So, for example, if you give goods to a carrier, you have a contract with that carrier to go and take your goods and deliver them somewhere else. Those two duties run together, but the bailment duties can arise in situations where there is not a contract. So if there was some defect in a contract that was formed, or it's been done gratuitously, in other words, you're not paying for the service of someone doing it. You're just moving your friend's furniture, for example. An action in bailment can still arise in that situation. Now, generally, the bailor, the person giving up the goods, again, in the absence of sort of tortious and contractual rules, they just have to give the goods. That's all they do in order to form this bailment. And bailment arises when the goods are delivered. It's not at the point where there's agreement. That's contract. Now, after doing that, if the bailment's for a specific purpose, the bailor isn't to interfere with it, but they do have a duty, though, to tell the bailee that the goods are dangerous or have to be used in a certain way to stop them from being dangerous, and that they have a duty to do that, and a breach of that duty can lead to a claim for compensation. Similarly, if goods are hired, remember that we talked about these implied conditions for the sale of goods? Now, when you hire goods from somebody, those implicit rules don't strictly apply because you're not selling goods, you're hiring them out. However, the rules of bailment step in, and they say that, look, if goods are hired, then similar rules to the Sale of Goods Act actually do apply. But the area of law that you can sue someone in is in bailment rather than in contract in that situation, assuming that these things haven't been agreed upon. And so the similar rules apply for them being merchantable and fit for the disclosed purpose. And again, this really mirrors the sections in the Sale of Goods Act. Now, the first thing to note about bailment is that the standard of care that the bailee have is an objective test. It's a reasonable person test. A person must take reasonable care of goods. Now, importantly, they're not under a duty to insure those goods. And in all situations of bailment, and again, these things can be trumped by contract, but assuming that there is no contractual discussion of this, if there is an act of God that destroys the goods or seriously damages them, the bolt of lightning, then the bailee is not liable. This is something that the bailor, when passing the goods to the bailee, they still maintain a great deal of risk. And to be honest, the standard of care for a bailee is pretty low. It's much, much lower than other duties that we've discussed in other areas of law, either in tort or fiduciary duties or contractual duties. The standard of due care that a reasonable person would have for looking after another's goods is not actually very high. And also note, though, that in particular, it's very low when it is a gratuitous bailment. In other words, where no money's changed hands. The goods are just being given to another party, and there's in the absence of a contract. Where there's a commercial arrangement, not necessarily a contract, but a commercial carrier, for example, is picking up the goods, then the standard of care, the courts have said, is usually higher. And I say usually because it's, even though it's a very, very old area of law, it's actually developed in the last 30 years or so. There used to be quite a very strict series of rules for bailment. And now that the courts have stepped back and they've really just left it up to a reasonable person test to try and determine how and where these things sit. And as noted, contract can modify the conditions of a bailment, but you can actually have conditions of the bailment modified where there is not a contract by giving instructions, even in a gratuitous situation, about what the two sides are and aren't going to do in terms of particularly damage to the goods, in terms of who's going to bear that cost, or instructions in terms of what the party, the bailee, can and can't do with the particular item of personal property. One of the situations where bailment can arise is what's called a lien. Now, this can happen in commercial arrangements where one party, as part of either a contract or, and again, in situations where a contract may have fallen through, has possession of another's goods. And we think about an example of this when we go and have, say, goods of ours repaired. Say, going to a mechanic and having your car repaired, having your computer repaired, thinking about, well, what would happen in that situation if the person who sent the thing in to be repaired didn't pay? Can they come and collect their goods? And the answer is, again, in the absence of contract, they can try, but the person in possession can refuse to return that until the amount has been paid. Now, it's important to note here that at common law, this, what we call lien across the property, is only a right to hold on to the item of personal property until that payment has been made. And this falls into two broad categories. You've got what's called a general lien, which means that you can ask to be paid for all things that you are owed by the person bringing in the item and giving it to you. These are actually pretty rare. Even though it uses the word general lien, these only actually apply in quite narrow circumstances. Stockbrokers, insurance brokers, bankers, and most commonly solicitors. So, for example, if you have multiple files and you owe a lot of money, if you want to come in and grab one of those files, at common law, the solicitor can refuse to give you that file until you've brought your account up to speed for all of the other accounts. Now, again, these things are modified by the legal profession rules, but at common law, that is how that works. The only exception at common law is wills. The way wills work is that you can always demand those, regardless of where your invoice is. So that's a general lien. Pretty rare that happens. It's much more common in commercial transactions, and you guys will probably be more exposed to this idea of a special lien, and that's possession of the property, usually in situations where it's been repaired, for example, or you're doing work on it, and that work hasn't been paid for, or there's a dispute over it. You do have this right to retain the property until that's been paid. But the key thing here is you do not have the right to sell it. Now, again, there are some statutory rules, particularly for those that own things like storage units. There is a Storage Liens Act. Now, in most situations, though, you hold on to the item of property until a reasonable length of time has passed. And again, for most situations, there's a statutory mechanism for you to seek some form of compensation. Certainly in sale of goods, there is a lien on goods that have been purchased, right, but not picked up. So that is a lien. And again, this is found in the Sale of Goods Act, where those rules will apply. And like all of these things, these can be trumped by contract. So the final area that it will look at is a very specific type of lien. And again, there are actually several different types of very narrow areas of law where the courts have developed over a long time very specific rules for particular industries or professions. One of them is to do with innkeepers. And at common law, there's quite a curious right for an innkeeper to both insure property that a guest leaves in a room, but also to hold on to that property if that guest doesn't pay for their food and lodgings. The case for this, it's a Queensland case, although it's probably the lead case in Australia, is Irving and Heffron. It's actually a Townsville case where a gentleman was staying in the Vale Hotel in Aikenvale, and he actually racked up a large phone bill and didn't pay. And the innkeeper went in, talked to the guy. They exchanged a few words, but the guy was half asleep. So he went in, the innkeeper went in, grabbed a whole bunch of notes from the guy's wallet and also a bag. And this actually came all the way to the Court of Appeal. And the reason it came to the Court of Appeal for such a small amount of money is this was actually a criminal matter, because it turns out that the bag was filled with cannabis. And so the issue before the court was whether the innkeeper had obtained that property lawfully, because property that's unlawfully obtained can't be used as evidence in that criminal trial. And so there the court said that, look, the money from the wallet was obtained unlawfully. Innkeepers can't do that, but they can take items of property until the amount has been paid. And so in that situation, the things in the bag were actually able and capable of being taken by the innkeeper. Therefore, that was evidence acquired lawfully. Also note that there is a statute that modifies this, although it does leave a lot of these common law rules in place. The main thing that it changes is the limit. So a hotelier is only limited to $250. So I hope this was a useful background to personal and real property. And we'll talk about securities and we'll talk about intellectual property in subsequent recordings.